Hi guys, and welcome back to Contract B. This is part 4 of the expanding series on illegality and void contracts. And in this part we are looking at void contracts rather than illegal contracts. And we'll be looking at voidness under statute and also common law. Particularly we'll be focusing on restraints of trade. And then we'll swing back to severance to conclude the series. So here we are back at our presentation, and we'll have a little look here at void contracts. As you'll see again, there's 4 pieces to this puzzle for this little bit of what we're going to talk about. And the issue of void contracts under statute is pretty darn simple, but we'll make short work of that in a minute. We'll also look at void contracts at common law. Now there's 3 little parts to that beastie. 2 of these we'll discover here in this orange section. And they deal with ousting the court, contracts purporting to oust the court, the jurisdiction of the court, and contracts prejudicial to marriage. And then we'll, in a separate section, look at restraints of trade. They are a very important form of clause that may be offensive to courts and may be found void. They are commercially significant, and as I say here, they're quite important, so do definitely read up on restraints of trade. I'm going to file that one away for practice. Okay, so looking at void contracts under statute, very, very simple. If a statute says that contracts, arrangements or understandings to do something or that have the purpose or effect of something are void, then guess what? They will be void. So one good example is section 64 of the Australian Consumer Law. No doubt you will have come across the consumer guarantees in the Australian Consumer Law. If a contractual term purports to exclude, restrict or modify those consumer guarantees, and you probably already know this, section 54 says that that term will be void to the extent that it purports to do so. So no tricks here, no smoke and mirrors. If the statute says that the contractual term is going to be void, it'll be void. Then we look at the first of the heads under common law that would dictate a contractual provision will offend public policy. And this is where a contractual term purports to oust the jurisdiction of the court. The public policy here is everyone needs to be able to go to court. If there's a dispute, you try and sort it out, sure. You try and use more expeditious forms of dispute resolution, sure. But the ultimate ability or the capacity of the party to actually go ahead and file proceedings can't be blocked off. It's just contrary to public policy. So you can provide that disputes can be settled in this more effective fashion if you wish. For example, disputes might be expressed to be settled by a specified body or a specified person, but as long as you've got recourse to the courts open eventually in the matter of a dispute, then you should be okay. So sometimes contracts provide for arbitration or a certificate of a certain person. They will be the arbiter of fact. So you do need to go ahead and you do need to engage with those processes that have been stipulated by your contract before going to court. Otherwise you will risk breaching the contract and you will also risk damages. But if the term in those circumstances purports to make the decisions of those other fora final and binding or conclusive in all the circumstances, then you're trying to block off the jurisdiction of the court. The provision itself will probably be void and the rest of the contract will likely be enforceable. And there's a little kind of red flag there to severability, which we'll cover off in just a moment. The next common law public policy head of a contract being void is contracts that interfere with, hamper, or embarrass the institution of marriage.
Knowledge.
Again, much like the contract purporting to foster sexual immorality, this particular form of a contract being void is of far lesser import nowadays. But in the old days, you did have contracts imposing a restraint on marriage or providing for future separation, or marriage broker contracts all being declared void. But with the changes to the Family Law Act, especially in relation to marriage and the way that you can provide financially for settlements, all of those are enforced, all of those kinds of contracts. So, as I said, this form of a contract being found void is much less of relevance. If you want to hunt it up in the text, 18.120 to 130, go and have a look at that. So they are the two minor scenarios where contracts will likely be found void at common law for breaching public policy. The other really big one is restraints of trade, and we'll look at that now. So here we are, rot. A restraint of trade is a term that is designed to protect one party. Okay, it stops the other party from engaging in trade in such manner as he sees fit. So generally speaking, everyone can engage in trade however they want, in whatever manner they see fit. A restraint puts some shackles over that ability to freely conduct trade. So the restraint can apply either during or after the contract between the parties. It might be a restraint that's actually contained as a provision in the contract between the parties, or it might sit alongside the contract between the parties, as it was in Buckley and Tuddy, and we'll look at that case in just a moment. Not all contracts will be subject to the restraint of trade doctrine, and here we have an ongoing debate, another one of the ongoing debates in this little corner of the law. Things like exclusive contracts of service. Are they subject to this doctrine? Maybe. Are they not? Maybe. Some cases suggest that they are, some suggest that they're not. If you want to have a little look at the niceties of that particular debate, have a look at sections 1845 and 47 of the text. That's the preliminaries. So what are restraints of trade? Rots. Well, we know that they involve some kind of shackle over a person's ability to freely engage in trade. These are the more common examples. Partnership deed. So if you become a partner in a law firm, you'll be asked to sign one of these. You usually have a provision in there that acknowledges that any partner leaving the practice must not practice within a so many kilometre radius of the existing partnership for a period of, insert period here, sometimes 3 years, is usually the standard practice. Vendor of a business. And here you might have an agreement not to set up the same or similar business within a certain radius, obviously to protect the purchaser where they've bought the business. They don't obviously want the vendor of the business going and setting up business across the road afterwards. Garage proprietor, here is the Amico case that we had a little look at before. And there was an agreement to take supplies of petroleum products exclusively for a period of, I think in that case it was 15 years actually, and that was held unreasonable. You might have rots in an employee agreement, so the employee will agree to give services exclusively to an employer and not work for a rival employer within, so many kilometre radius for so many years after termination of employment. So they're your very common forms of restraint of trade that you'll come across in practice. First of all, when you're looking at restraints of trade, the first cab off the rank that you need to think about is whether or not the term that you are worried about is actually a restraint of trade. And in order for it to be a restraint of trade, it has to somehow curb your freedom to carry on business. So there has to be an ability to carry on trade or business or your employment, your skill in trade in the manner you see fit, and then this term must somehow cut that right short, must shape it in some way. Now, if it is a restraint of trade, boom. Second thing, second cab off the rank, there is a presumption that you hit up against, and that restraint of trade will be presumed unenforceable and void, but not illegal. Okay, so you've got a presumption there, rots are out. Okay, the presumption will only be rebutted, and here we have a two-stage rebuttal process. The first step is you've got to show that the restraint of trade was reasonable as between the parties to that provision. Okay, the onus here obviously is on the person that's seeking to enforce the provision, and that's usually the covenantee, the person that's getting the benefit out of the restraint of trade. If for some reason that party cannot discharge that onus, it'll be unreasonable in the interests of the parties. That's it, end of story. The rot will be contrary to public policy and therefore void. Okay, end of story. If not, if the provision is reasonable in the interests of the parties, then you've got to go on and look at the second step in the process, and you've got to show that the provision is reasonable in the interests of the public. Okay, here the onus shifts to the other party, so the party that's seeking release from the restraint of trade, and they will have to show that even though the restraint is reasonable as between the parties, nevertheless it's going to somehow hurt the public, and for that reason it should be struck out and void. Okay, so that's your two-step process. Unreasonable between the parties. This particular part of the two-step process itself has two sub-steps. So the questions are, does the covenantee have a legitimate interest? And if it does the restraint go no further than protecting that legitimate interest? So turning to the question of legitimate interest, the main justification here is that there's something of a proprietary nature that you're trying to protect. Okay, you're trying to put some contractual terms around something to shield it from damage or loss or injury from the other party's conduct. Either it'll be proprietary interest, as I said, or something analogous to property. So you can see down the bottom there, confidential information, trade secrets, all of that kind of thing will be considered analogous to a proprietary interest. Probably the most common one is trying to protect goodwill. So that's common in terms of sale of business. What are you buying when you're buying a business? You're buying the goodwill of the business. You're buying whatever attracts people in and makes them buy from that business. Now, obviously that goodwill is going to be impaired, as I said on the other slide, if the vendor could just sell the business to you and then go and set up close by. All the old customers would just walk away to the vendor's new shop. So that's why you need a restraint of trade in those circumstances to protect that goodwill. Similarly, where you've got employment contracts, usually the employer will be trying to protect their goodwill from conduct by the employee that's kind of a bit naughty. For example, if they try and solicit clients after they leave the company and nab all of the company's trade that way. So you can see there are various different types of interests that might constitute a legitimate interest. Generally speaking, in terms of employment contracts, courts will be stricter. So they'll probably find that the restraint of trade is not in the aid of a legitimate interest where it is operating harshly on an employee, particularly where it has the effect of not allowing the person to work at all or in some very minor fashion, The other problem here with restraints of trade in employment contracts is that usually the employee will want the job so badly that they'll pretty much sign anything. So you have the possibility that the provision might have been extracted because of the superior bargaining power of the employer. Obviously, courts don't like to countenance this, and then they'll strike the provision down as a restraint of trade, contrary to public policy, and void. And here we have Buckley and Tuddy, and it's not really a terribly difficult case, just slightly unusual because the restraint was not actually contained within the contract between the parties themselves. It kind of sat alongside that. The plaintiff played for the Balmain Tigers, and the restraint was contained within the rules of the New South Wales Rugby League. There was a retention transfer clearance system, and that unfortunately meant that a player on a club transfer list could only play for a new club if the new club paid a transfer fee. Now, if they didn't, a player couldn't play in Queensland, New Zealand or England, the big three, without clearance from their club. And here the plaintiff was on the Tigers' retained list but wanted to get favourable terms elsewhere. The big question obviously was the New South Wales Rugby League system an unreasonable restraint of trade? Yes, it was held that there was a legitimate interest here. Okay, so the first step had been satisfied. What was that legitimate interest? The legitimate interest was to protect the league and to ensure that the teams were strong and well matched. Okay, that's a fairly reasonable kind of interest to try and protect. However, the restraint went beyond what was necessary to protect that reasonable or legitimate interest because a player could be on a retained list indefinitely even after ceasing to play for the club, or the club could fix such a high transfer fee it stopped the player transferring to another club. And in those circumstances, because the clause went beyond what was necessary to protect that legitimate interest, it was struck down as an unreasonable restraint of trade. In relation to sales of business, often, as I said before, restraint is necessary here to give the purchaser what they need, and the pull of public policy is really less strong than, when you're looking at the poor employee. And here we have probably the mother of all restraints of trade that was upheld. This was 1894, and Nordenfeld got himself a pretty good deal here. He sold his munitions business to Maxim for $1 million. That should be pounds. Wow, £1 million in 1894. The restraint of trade was that Nordenfeld couldn't be involved in the munitions industry or any other business that the company was involved in for 25 years. There was no geographical limit on this thing, so the thing applied worldwide. That's an enormous restraint. And it went all the way up to the House of Lords. Not surprising here. Look at the date and look at the importance of munitions at that date. Okay, the House of Lords said that latitude was required in sale of businesses because it gives the purchaser all of the consideration that they're purchasing, like we've been talking about, and also these kinds of restraint allow the seller of the business to command a higher price than perhaps they otherwise might if they were free to go and set up business in opposition. So taking into account the worldwide nature of the business and the huge purchase price, the restraint was upheld. The only thing that was struck out was the any other business portion of the restraint. So there was a whopping 25 years worth of restraint there, well past World War I. And so Nordenfeld missed out on a whole lot of munitions business right there. So that's the Nordenfeld and Maxim Nordenfeld decision. So the second stage of the two-step process is that the provision must go no further than protecting the legitimate interest itself. And here the court's going to look at a few different things: scope, activities, bargaining power, consideration, context. And when they're looking at scope of the restraint of trade, the wider the area of the restraint of trade and the longer in time the duration of the restraint of trade, the more likely it's going to be struck down as void. Activities, if the activities falling within the restraint are not related to the covenantee's legitimate protectable interest, like we saw in Nordenfelt, the more likely the restraint will be struck down. Bargaining power also, as I said, particularly in relation to employer-employee contracts. If the parties are not bargaining on equal footing, then the court's going to take a more strict approach there. Consideration, again, look at the Nordenfelt case. If there's been a huge consideration paid for the restraint, it's probably going to be enforceable. Context, if there's something serious in the air, if the context suggests that the parties were in a situation like agreeing a partnership agreement or where they've already got legal advice, again, the restraint's more than likely going to be enforceable. So they're the kinds of things that are going to be floating around in the court's weighing up process of whether or not the provision goes further than protecting the legitimate interest or not. Now, how can we get around the issue of reasonableness between the parties? Some cases do use this step or ladder set up for their restraints, and you'll see in contracts, they'll go down in terms of area and they'll go down in terms of duration typically. So you'll have an area of 50 kilometres, no, or an area of 25 kilometres, no, an area of 10 kilometres. Then you have like a period of 25 years, a period of 10 years, a period of 5 years, a period of 3 years, a period of 1 year, for example. And then that will get coupled up with a severance clause so that the court can just take out their blue pencil and work out which one is the most applicable. Now, if there are too many variables and you go overboard with this kind of thing, you're going to risk the court saying, no, we can't take a blue pencil to this. What you're doing is not asking us to cut out some bits that are unenforceable and keep the rest. You're actually asking us to rewrite the contract, and what you've given us here is just void for uncertainty. So that's the risk you run. If you're going to use this kind of thing, you have to do it in a very circumspect manner, because you go overboard, like I said, and it may well be struck down. So assuming that you have been able to show that the restraint is reasonable in the interests of the parties, then the onus shifts to prove that even though it might be reasonable as between the parties, nevertheless it's injurious to the public, and therefore that party should be released from the restraint. And here we have the case of C Convenience Stores and Wavell Plaza from Adelaide, where I come from. Nothing magic here. The covenant prevented land being used as a petrol station. The question was that an unreasonable restraint of trade? It was reasonable as between the parties, but what about the public's interests? Well, there it was argued that the public did have an interest in encouraging competition in retail petrol sales, and for that reason, it was unreasonable in the interests of the public, and that argument was upheld. So there are some, not many, cases that will get over the line, and even though the restraint has been shown reasonable in the interests of the parties, nevertheless it will still be struck down because it's not in the public's interests. So that is the doctrine of restraint of trade, and now we need to swing back to the issue of consequences and the issue of severability, and we'll come back in just a moment to consider that.